the appeal of the Attorney General of Trinidad and Tobago against Akili Charles.
Yes, Mr. Rambo.
Good morning, my Lord. I appear with Mr. Rowan Pennington Benton and Mr. Adam Riley for the appellant. My learned friend, Mr. Peter Knox, Queen's Counsel, and Mr. Daniel Goldblatt appear for the respondent. My Lord, I might start by saying that I need to crave your indulgence. I've been recently diagnosed with some damaged vocal cords. And I will, of course, endeavor to carry on. But I've asked for the volume on my mic to be turned up, and if I need assistance to read anything, I'll probably have to enlist the services of my junior, Mr. Riley.
Please do that as much as you like. Don't wait until it all goes to rat and then ask for assistance.
Thank you, my Lord.
At the moment, you are loud and clear.
Good, my Lord. I've been resting it for today.
And if you want, equally, if you want a minute's pause, or 5 minutes pause, or a short break at any stage, because you think that will just enable you to get the strength back, just ask, and you will have.
It's very kind and considerate of you, my Lord. Thank you very much. So now this appeal comes from it's an appeal against the judgment of the Court of Appeal from Trinidad, and it's dated July 15th, 2021. And that appeal, really, it's the culmination of litigation concerning this appellant that has its genesis in a very controversial matter in Trinidad, which had to do with the elevation or promotion of the then Chief Magistrate to the position of a High Court judge. The murder charge was laid on December 5th, 2010, and on June 1st, 2017, the first preliminary inquiry, which had been in train for some 5 years and was nearing completion, was halted, and the Chief Magistrate and the then Deputy Chief Magistrate indicated to the appellant that all part of matters would have to be heard de novo. Now, it's not just the indication that the matters would be heard de novo. When I take you to the evidence, you will see that it was the manner in which that was communicated. The presiding magistrate said she had been instructed to make such an order and a declaration in open court. And you will see when I take you to the evidence, because the arbitrariness that pervades the entire factual matrix in this case is what we want to highlight. The DPP, who is an independent constitutional office holder, raised questions with the presiding magistrate when that announcement was made. Could you give me the assurance that the Chief Magistrate, the substantive Chief Magistrate, has in fact resigned her office and is in fact appointed as a High Court judge? And the response from the presiding magistrate was she couldn't assist with that. And after that, the DPP wrote a letter, which we'll come to show you how the events unfolded. Now, my Lord, the interesting thing about this is that the facts are largely not in dispute. The relevant facts are not in dispute in this matter. In fact, the case could have been done quite easily by taking judicial notice of what was already in the public domain, the subject of judgments from the Supreme Court of Trinidad and Tobago, and indeed matters that had been engaging important institutions via the media by a series of press releases from the office of the JLSC, under the hand of the Chief Justice, and of course other chief functionaries of the state. Now, my lords, we say that when one looks at the totality of the evidence in this matter, what it shows is that the delayed trial judge was justified in making the finding of maladministration, arbitrariness, and almost akin to misconduct on the part of the state that resulted in a fundamental unfairness that met the threshold for triggering a breach of the right to protection of the law.
So you put it that way, maladministration and arbitrariness,
Yes.
Amounting to a fundamental unfairness.
Yes. And I say that, my lord, you see, now, when we had to draft this case, and we're doing this on the trot, Mr. Akili Charles is in prison for 9 years as a young man. He's lost the roaring years of his youth. He's in prison.
In total?
Yes. And he is there in prison, and he can only depose to such facts as he would know. It's not like if they have computers in the prison. What we rely on is what he would have known that was in the public domain that was not refuted by anyone. And those, based on those, on that situation, we say there are two incontrovertible and undisputable facts, undisputed facts. That is, that the Chief Magistrate is appointed a High Court judge by the Judicial Commission, and at that time, she left in her wake 53 part-heard matters. Those two facts are not in dispute, my lords. Now, when we framed the case, we could not, obviously, have framed the case to pin the donkey's tail on any institution of the state or any particular office holder. What we knew were those two incontrovertible facts and many things that occurred in between. But it was not for the appellant, respectfully, to say this happened, and this is how it happened, this is why it happened, and this is who is responsible. That is not a matter. Those are not matters, facts that would be within the knowledge of the appellant. That would be the inner workings and operations of very sacred high public office holders, members of the Judicial and Legal Service Commission, the Chief Magistrate, the Law Association, which had been writing and corresponding. Those are the people who would know about what happened on the inside.
Presumably it's well understood that if one is appointed to the post of High Court judge, then one can't carry on in a lower judicial capacity to deal with your outstanding caseload.
Well, my Lord, that seems to be logical, and it seems to be quite reasonable. The problem is, when I take you to facts, you'll see that the logic that leads to that assumption just doesn't hold in this case. Because when the DPP made that inquiry, I will show you what the answer from the court was, and I will also show you, my Lord, that it is possible to say that you're appointed, but that the appointment could be, for example, deferred. So that the fact of the appointment by itself does not ipso facto mean that you have demitted office immediately, and that all the part-heard matters were therefore suddenly thrust into vacillation. So, my Lord, we say in any event, we say therefore that the comments which the court will focused on, which troubled it in terms of the Judicial and Legal Service Commission, we say, A, those comments can be easily justified on the evidence, and even if it's not justified, it was not necessary for the decision that was made. It could have been viewed as obiter dicta. We say that the functionaries of the state that were involved were the ones who would have had the information and should have put evidence to meet this case that we had brought. Now, even if we're wrong on that, and the court of appeal found that the judge focused on the conduct of the JLSC, Judicial Commission, and that was not a specific plea, because as I said, to be fair to the appellant, we were not seeking to pin the donkey's tail on the JLSC. That wasn't our pleaded case. But if the judge went off on a frolic of his own, or it was obiter dicta, or it formed part of his reasoning, the Court of Appeal couldn't simply just dismiss the case. What they had to do was to consider then the matter afresh themselves. So the trial judge got it wrong, so it now falls to us to look at the facts and make a decision and come to a judgment in this matter, or we remit it to him to be reheard in accordance with our findings and the guidance we provide. What they could not do is what they did, which is to decide a major constitutional case on dealing with fundamental rights on an unprecedented historic state of affairs in the Republic of Trinidad and Tobago, on an arid technicality that turned on a pleading point. which I'll come to. Now, my lord, that pleading point, there are two originating processes in Trinidad to start a claim. It's a regular claim form and a fixed state claim form. It's the Lord Wolf rules. We've had some adjustments, but by and large, they're the same. And if you started with a fixed state claim, the practice is that you would put the grounds, the relief in the fixed state claim that you're claiming, because that's the originating process. You put the relief you're claiming and the grounds upon which you're claiming those reliefs in the fixed state claim form. The affidavit generally contains the evidence in support of that claim. And that's how it's done. Now, it is true, there's a rule, Part 56, which is cited in the Court of Appeals judgment, that says, well, you should, in the affidavit, put the grounds and the relief. But to be quite frank, many practitioners in Trinidad, we don't do it because it is simply a matter of copying and pasting what you already have in the fixed state claim form in the affidavit. And the reason it's not done sometimes is because the state takes objection and says the affidavit is for evidence. And your grounds and your relief, that's not evidence. So rather than to avoid that, over time, the practice has developed where look, the affidavit, you'll stick to the evidence, and the grounds and the relief is in the fixed state claim form, which is the originating process that's employed. The Court of Appeal could not, with the greatest of respect, look at the affidavit in a vacuum and not even mention in its judgment the fixed state claim form, in which there were grounds and relief. One accompanies the other. They are to be read together. And if the rule in the rule of procedure, which required it to be replicated in the affidavit, if that rule has to be interpreted, at best, it would have been a mere irregularity. It could not operate to defeat the case. The court could have said, well, look, we'll proceed with the case, but file a supplemental affidavit simply to replicate the grounds from the fixed state claim form. That's all. Now, my lord, once a prima facie case is made out, in my respectful submission, which we did, the burden in public law proceedings shifts to the public authority, the state, to then give an explanation and justification, to provide reasons. It's the growing duty of full and frank disclosure that is owed by the state at a time when there's a growing recognition and acceptance that in public law, it is not the same approach as one would take in a commercial case where there's hard-fought litigation. Because in public law, the focus of the court is on vindicating and upholding the rule of law and focusing on the public wrong, or in this case, the breach of the supreme law, the fundamental rights. And therefore, the court in this case should have found that the state breached its duty to make full and frank disclosure, that it sidestepped the issues raised in the claimant's case, and I'll take you to the loan affidavit they filed, and it should have been, therefore, applied the principle that adverse findings and inferences should have been drawn from the state's stony silence in this matter. The Court of Appeal appeared to be fixated with the finding that the JLSC, with the finding against the JLSC, so much so that it was blind to what the claimant's case was before it, against the state. And we say, well, at a part in the judgment, they said, well, I was asked, well, so how would you put it? I said, well, it's akin to it's akin almost to res loquitur. The facts speak for themselves. And the question was, well, could that apply? And I said, well, yes, because the facts speak for themselves. We've crossed that threshold to trigger the state's responsibility to provide a substantive response in this matter. Can I take you to our submissions in the court below to show the court how it was put to the court. And I start by taking you to, can I start first by taking to page 1247?
Pick a
Page
1247.
1247.
Yes, sorry, yes. Just to make good the point that, in response to my Lord Burrows, to make good the point that the JLSC is responsible for fixing the date of appointment for any judicial officer. That's because the Judicial Commission has adopted the Public Service Commission regulations, and Regulation 31 says that the date of appointment to an office in a particular service within the, that should read judicial service, shall normally be the date when they assume the duties. Sub-regulation 2, the date of appointment shall be the date as the Commission may specify. Now, my lords, the Court of Appeal finally was wrong to say that that the respondent was prejudiced because they did not know what the case they had to meet was. And I'd like to start by taking you immediately to what the case was, and I'll ask that we turn to page 24.
We're plunging into the middle of a document here.
Sorry.
Mr. Ramlogan.
Oh, sorry. This is the fixed date claim form.
I thought it probably was, but thank you.
Starts at 9. It starts at 9, and at the top, you'll see fixed date claim form.
Page 9.
Page 9, yes. That's the beginning of the document. It's the fixed date claim form.
Yeah.
And at the top of page, we immediately see the claimant who's currently remanded. And at the top of page 10, we say what the claim is about. It's in respect of the violation of his constitutional rights as a consequence of the state's failure and or refusal to pay for counsel of his choice to represent him in the second PI, which has been occasioned as a result of the failure and or conduct of the judicial arm of the state, which resulted in the first preliminary inquiry being started de novo. So that's at the beginning. And then we go to page 24. And at ground 39, we say the claimant is entitled to the protection afforded by his constitutional rights to be protected and properly represented through full and proper access to counsel. It is expressed that any person who has been arrested and detained has an unfettered right to retain and instruct counsel of their choice and to communicate with them. The colossal misstep of justice has denied the claimant that right, and he seeks appropriate redress. And at page 26, ground 44, we say the claimant is not responsible for, quote, the travesty of justice occasioned by the resignation of the former chief magistrate, and therefore cannot be held responsible for the consequential financial effects on himself and other litigants who had their PIs parted and which now have to be heard de novo. It is unfair, unreasonable, and oppressive if the claimant, as a result of the actions of the defendant, was effectively denied his constitutional right of access to counsel of his choice as a result of a debacle he had no control over. The claimant paid a significant sum to ensure he had counsel of his choice at his first PI, and he was now being denied his right as a result of, in the judgment of Gobe, the failure of the state. And the failure and refusal to pay the legal fees occasioned by the second PI is therefore unfair and oppressive and breaches the fundamental principles of justice and the rule of law, and it's not reasonably justifiable. And then we say in ground 47, in the premises, we should be granted the relief sought in the motion. After that, can I take you to page 589 next? This document starts at 586, my lord. And this is a judgment of the High Court, because when the de novo order was announced, we had filed with the appellant had sought judicial review of that order. My lord, I remember it might be my Lord Burroughs, but I believe in the other Akili Charles matter with the right to bail. The question was asked of me as to how is it that in Trinidad people can remain on remand for up to periods up in excess of 20 years, awaiting trial for murder. And the answer I gave was that when you have an order for a retrial or there's a hung jury, what happens is that you go to the back of the queue, and that's how they remain inside. Now, I say that because those are the things, that would be one of the possibilities and things that would be operating on Mr. Charles's mind. That's why this judicial review was filed by the appellant. And I take you to this judgment, and I'll take it up at page 589 to show you that these are the facts that are not in dispute. Paragraph 6, on April 12th, Ms. Caesar was sworn in as a puisne judge. Her appointment raised many concerns about the impact that the same would have on part-heard matters over which she presided as chief magistrate. What followed were numerous press releases from the judiciary, the Law Association, Ms. Caesar, and the GLSE. These releases revealed definite uncertainty as to whether Ms. Aya Caesar had resigned as chief magistrate and what was to be the way forward in disposing of part-heard matters. I believe that answers my Lord Burroughs' question, my Lord's question as to, well, if you're appointed as a judge, does it not mean, obviously, that you have resigned? And as you can see, I'll come to the evidence. There was definite uncertainty. And on May 24, there was a meeting convened by the Chief Justice comprising the DPP, the first respondent, the Law Association, and other judicial officers. A press release was issued by the judiciary indicating that a consensus was reached at that meeting with key stakeholders to have 53 part-heard matters restarted de novo by other members of the magistracy. The applicant's PI is included among those 53. No invitation was extended to either the claimant or his attorneys to attend that meeting, nor were they represented. I pause there. The de novo order, which the chief magistrate said she was instructed to make, was as a result of a meeting with various stakeholders, including the prosecution, but no one from the defense. And then on 1st of June, a number of matters which were part-heard were called. According to the affidavit in support, the first respondent proceeded to explain that the former chief magistrate had vacated office as she had been instructed in order to that all matters were part-heard will be started afresh before a different magistrate. At the bottom of the page, the DPP raised concerns, but notwithstanding these two sets of representations, it appears that the applicant would be facing a new PI together with the associated costs and time while being incarcerated. It raised serious questions as to whether she was acting independently. That's the applicant in this matter. And then I take you next now to paragraph 20 on page 593. And the judge says about a submission made by the state, he said, two observations must be made in relation to this submission. Firstly, there is no suggestion that the decision which was made was the only one to be made in the circumstances. There may very well be other options which may have been available to the first respondent, which, because she was supposedly acting under instructions, she may not have considered. The court is not possessed of all the alternatives to make such an assessment, but some were referred to by the previous chief magistrate in her affidavit in another matter. And then we go to page 601, paragraph 47. The judge says, having determined that there may be an arguable case, even if there was a way to appeal at this stage, the facts of this case clearly constitute an exceptional circumstance, especially in light of a prisoner on remand who, 7 years after his incarceration, is nowhere closer to having his day in court to attempt to clear his name. The order for the de novo hearing might be tainted, and there is a distinct possibility that it may not be a valid one, which obviously can impact on the applicant down the line. To my mind, it is imperative to have the same reviewed as early as possible to minimize obvious prejudice. To my mind, the fact that this case is an exceptional one is self-evident. It is difficult to pigeonhole cases into particular categories, but this one crosses the Rubicon as the mix of uncertainty has propelled it out of the norm.
I'm sorry, I've just lost where you were there citing from. Can you just give me the page?
Page 601 on to 602. Sorry.
Thank you. 601, thank you.
Yeah, 601, paragraph 47.
Thank you very much.
So he said, the judge said this takes it out of the norm. The thought of refusing leave in circumstances where the decision-making process in relation to a person who has been incarcerated and presumed innocent for over 7 years is impugned seems contrary to the principles of justice. To my mind, there is no effective and convenient manner of dealing with this imbroglio other than to have the administrative court review the circumstances and process as a matter of urgency rather than to await the outcome of the already tarnished process. Leave was granted. The state had filed, while this GR was going on, the state filed an interpretation claim. And the state was the applicant in that interpretation claim. That claim was filed on the 4th of January 2019. And, I'll take you to the judgment, which was the 4th of January 2019, at page 659.
When was the claim filed?
Sorry, my lord?
When was the state interpretation claim filed?
1 second, my lord. Yes, I think that might be right. Yes, 1st September 2017.
Thank you.
Yeah. I'm grateful. Now, my lord, so I take you to page 659. This is the judgment now in the interpretation claim, but the judicial review after leave was granted, it was to be heard together with the interpretation claim. And the interpretation claim took precedence because the Attorney General and the state made the application. At page 659, the judge says, paragraph 2, both these proceedings arose out of what can fairly be called the debacle which ensued following the appointment by the JLSC of the former Chief Magistrate to the High Court on the 16th of April 2017, leaving 53 party matters behind. The common factual background, as indicated in the submissions, is set out hereunder. Now, this is the state as the applicant, and this is the common factual background. That's why I say the relevant facts are not in dispute. And the background, it starts at paragraph 1. I'll go to paragraph 4. On June 1st, on page 660, paragraph 4, on June 1st, the DPP attended before the acting Chief Magistrate in the pending matters, and following this, wrote to the Chief Justice, both as Chief Justice and as Chairman of the JLSC. The letter was captioned, Outstanding Parted Matters before Her Worship Marcia I. Caesar and her current status as a magistrate. The contents of the letters are set out. I'll just read the last 5 lines. The acting Chief Magistrate curiously declared in open court that she had been instructed to treat with the parted matters called in that way. This could be tantamount to an unlawful fettering of the court's power to deal with each case on its merits. I raised with the acting Chief Magistrate at the top of 661, I raised with the acting Chief Magistrate my concerns about the status of Her Worship, Marcia I. Caesar, and I inquired whether the acting Chief Magistrate could state as a fact that Her Worship, Miss I. Caesar, had resigned as a magistrate. That is to say, she was no longer a judicial officer. In reply to my inquiry, the acting Chief Magistrate said that she could not answer that question. Now, my lord, this is an open court. This is the DPP of the country, who is the chief prosecutor for all these 53 matters. And he's asking the very simple question, well, if she's been appointed a judge, could you confirm here in open court for the record that that she has in fact resigned as a magistrate? And the answer was, well, she could not. So she's been instructed to make a de novo order, but without even knowing the basic information of, well, or being informed, to be fair to her, as to whether or not, the substantive chief magistrate has in fact resigned. Now, I take you next to paragraph 7 at page 662. The Law Association jumps into the fray, and it issues a press release. And it says, it is unfair that anyone should suffer the expense and anxiety of an avoidable repeat trial. The full extent of the prejudice which may have been caused is not yet known. We will be seeking to engage with the Honourable Chief Justice, the Attorney General and DPP over the coming days to try and find a working solution. And then, at paragraph 9, on the 27th of April, we had 2 press releases. One from the President in paragraph 8. So the President notified that he had received the letter of resignation. That's on the 27th of April. And then on the 27th, a further press release was issued by the judiciary. And this is what it said. It said, given Ms. Caesar's commitment to address her outstanding matters, and having regard to the hardships likely to be experienced by accused persons, witnesses, and the legal fraternity, should matters be restarted, the JLSC has met and agreed to restore Ms. Caesar to the magisterial bench. This is a sudden twist, a sharp bend. And the JLSC, on the 9th of May 2017, the JLSC issues another press release. And it says, the JLSC was of the view that the situation was sufficiently grave to trigger a disciplinary inquiry. But after some further discussion, it was agreed that Justice Caesar should be given an opportunity to return to the magistracy to complete the matters she'd left unfinished. The JLSC was of the view that this was a viable course of action as a means of relieving possible hardship to defendants, victims, and other interested parties. They said she'd accepted personal responsibility for the matter and the events that had unfolded, and she was invited to consider her options. And it ends by saying no promises were made to Ms. Caesar that if she finished her part of matters, she would be returned to the High Court bench. I mean, if this is not arbitrariness, then what is? We are dealing with judicial appointments. There are people who have been waiting, 7, 10 years, and their PIs are nearing an end. Could you imagine the distress, the anxiety, the frustration of these young men? It is akin to what the board said in Pratt & Morgan, with the mental anguish of having a death penalty hovering over your head. And in paragraph 11, we are told that there was a meeting now, and another press release came. This is on the 25th of May. And it says that they had a meeting with the Criminal Bar, the Law Association, Acting Chief Magistrates, Senior Magistrates, and the Registrar. Everyone except the people that matter the most, the appellant. Consensus was reached, or his counsel rather, consensus was reached at the meeting. We agreed to have all 53 matters heard, restarted de novo. Acting Chief Magistrate will preside over them, and all 8 other matters that have not been started will be managed, which have not been able to be managed by the Acting Deputy Chief Magistrate. Then we come to paragraph 14. The Chief Justice replies to a letter from the Law Association, which poses questions which are set out in paragraph 12. And it's a without prejudice response. And the Chief Justice answers the questions. And the first question, you will see in paragraph 12, Roman numeral 1, is, did Ms. Caesar resign as Chief Magistrate when she was appointed a judge? If not, how was her employment terminated? Is there any documentation recording the termination of her appointment in the magistracy? Has she been restored as Chief Magistrate or was an ordinary magistrate? These are pertinent questions. The administration of criminal justice was being brought into disrepute. And the response from the Chief Justice: at the time of writing your letter, you may not be aware that the stakeholders met to find solutions, and the judiciary has adopted the only feasible option currently open to it, which is to reschedule the matters before other magistrates and afford them priority. It is in the extraordinary circumstances the Attorney General, properly and in discharge of his public duty, filed this interpretation claim. I take you to page 676. And at page 676, paragraph 29, this is what the judge said about the claim for judicial review, which was secondary to the interpretation claim, really. The claim for judicial review was pursued before me on grounds of procedural unfairness. No one suggested that the unavailability of a magistrate would render the proceedings abortive and should automatically result in discharge or a permanent stay. The law couldn't contemplate that. This is not to overlook the extreme hardship, oppression, and prejudice that is bound to be suffered by the claimant and many others similarly circumstanced as a result of the de novo order, which consequences might be more appropriately considered if Mr. Charles pursued his claims for relief under the Constitution. These have not been addressed in this year. The judge, in the judicial review proceedings, having regard to what had transpired, was telegraphing to Mr. Charles, well, look, I don't want to deal with this on a judicial review because, I think it's best that you bring a constitutional claim. And it can, your distress and your hardship and so on would be better addressed under the shelter of the Constitution as a sacred and supreme law. That's what we did. That is precisely what we did. And then in paragraph 30, she mentions the dire consequences of the appellant are disclosed in his affidavit. He's been charged for murder and in custody since December 5th, 2010. The conditions there were found by this court almost a decade ago to be inhumane, and there is no reason to believe that there's been any improvement in those conditions. We live in Trinidad. We visit prisoners in the jail, and we know the conditions. More than 60 witness statements have been received, and several witnesses cross-examined. 60 witness statements. He paid $150,000 for legal representation, which he cannot recover. He'll have to pay for representation for a new hearing. He has no means of raising further funds for his defense. That he should have to start over is oppressive. What happened here is a travesty of justice. Paragraph 31. The stain on the administration of justice will remain indelible long after the cries and protests of justifiable, angry, suffering prisoners have gone quiet, and long after the families of the victims, who too have been waiting for justice to be done, resign themselves to further delay. It may go some small way to alleviating the pain and injustice of this on all sides if those responsible are held to account. Almost 2 years since the Chief Magistrate's elevation, the initial shock and disbelief that this could have happened has been dulled. But the ill effect on public confidence in the administration of justice and the institutions which allowed this to happen, whether through lack of due diligence, as suggested by the Law Association, or recklessness, will persist. So far, the financial cost to the taxpayer is limited to the cost of litigation, and these are other cases which have been filed as a result of the colossal misstep. The JLSC is no longer a party on page 678. The JLSC is no longer a party to these proceedings. And I hope it's not too late to humbly offer a bit of practical advice. That is to include on applications in the case of magistrates being considered for elevation to the bench as the first question, how many parted matters do you have? Well, I mean, that's as practical advice as you can possibly get. Some may say it's common sense. I mean, this, of course, should be backed by a system which can verify the answer. Indeed, one would think that the state of the magistrates list, especially state of parted, would be an important indicator of the candidate's name and case management skills. Now, my Lord, these judgments are exhibited by the appellant to his affidavit in support of his claim. I'm not reading them from a bundle of authorities. I'm reading them because these are exhibits to his claim. It forms part of his evidence. And this interpretation claim, where the judge begins by saying what is the factual matrix that's not in dispute, the state did not appeal it. There was no appeal against this judgment by the state, none. So the state must be taken to have accepted the wisdom of this judgment and the correctness of the ruling.
Mr. Ramlogan, we all know that you appeal orders rather than judgments.
Well, of course, my lord, yes.
I'm not sure that a lengthy pursuit of that point will be
Fair enough, my lord. Fair enough. But my lord, what I intend to focus on more is the fact that the relevant facts were not in dispute. And the state as the applicant, one would have thought that if there were any findings of fact or anything wrong, that would have been corrected. That would have been corrected in their submissions at minimum. And can I now take my lords to the submissions in the court below? And I'll ask my lords to turn to page 45.
By court below, do you mean the Court of Appeal? Or?
No, this is in the High Court, my lord.
The High Court.
To show how it was put. Page 41, I could start at 41, sorry. That's wrong. At page 41, this is paragraph 2 of the submission. And it says, the unprecedented and remarkable state of affairs that's given birth to this claim makes it unique and important. The factual matrix demonstrates a wholly unacceptable and palpable exercise of arbitrary and capricious power on the part of the state. It is an entirely unacceptable state of affairs, and as will become apparent in these submissions, a travesty of justice, an affront to justice and the rule of law. The defendant seems to have taken an overly rigid and methodological approach to its submissions. This, we say, ought not to be the proper interpretative method to be utilized by the court in determining a matter of this nature. The approach required is a philosophical jurisprudential approach that is rooted in the rule of law and the notion of justice, bearing in mind the intense state of judicial activism in relation to the development of the concept of the right of protection of the law. This would, of course, become apparent in our submissions below, but we respectfully say this is the lens through which the court must analyze and appreciate this very important case. The claimant, in the exercise of his constitutional right to retain and instruct counsel, has been deprived of the benefit of that right when he was suddenly called upon to retain defense counsel again as a consequence of an order that his matter be reheard de novo. The issue in this case is whether an aggrieved citizen is entitled to have the state pay for the retention of his defense counsel pro bono for the de novo hearing. The context to that is very important in terms of the preceding paragraphs. And I take you next to page 45.
Would you accept that that paragraph, the issue in this case, may be regarded as somewhat narrower than you would now regard yourselves as having really intended?
Yes, Malone, I accept that, which is why I take you to different parts of the submission to show that is it's got to be taken in context. It's preceded by the paragraphs I read, and I'll take you next to page 45, but I do accept that, my lord, yes. It's a short answer. My lord, at paragraph 8, which starts at page 44, sorry, it started actually at page 43. Paragraph 8 recites the factual matrix, and I will show you in the state's submissions and response, they said they accepted this and agreed with this factual matrix. So paragraph 8, and I'll take you to, in that paragraph 8, I want to take you to I, which is at page 45. And basically, the matter had to be restarted de novo. It left the claimant in an invidious predicament. He had previously paid for his counsel. He could not afford to rehire him. He had no money left to do so. And he therefore filed this motion. At the hearing, letter K, at the hearing of the application for injunctive relief, this court raised concerns about the second PI continuing while the claim was pending. We indicated that we didn't want to delay that second PI because of the prolonged period of incarceration. and I indicated there was a practical problem with legal representation. The PI was scheduled to commence 5 days later. We filed this case 5 days before, and that was because there was no response to our pre-action protocol letters. And the court agreed to expedite the hearing of this claim and gave directions for the progress of the matter. They asked us, the judge asked us to have discussions to see if we can devise a practical solution, and which we were in fact able to do at letter L. A practical solution through collaboration with Mr. Sturge, who was prepared to represent him as the second PI in recognition of the fact that he was a victim of the unfortunate circumstances. But the claimant had to give an undertaking to pay for his representation out of damages that may be awarded in this matter, in default of which the claimant would remain liable to pay the legal fees. And therefore, on the 21st, he was discharged on a no-case submission. And at letter N, we highlighted several challenges with the legal aid scheme, including inadequate complement of staff, small sums paid to attorneys, low level of dedication, lack of competence, etc., etc. So, my Lord, if I take you to page 105 next, paragraph 2, page 105. This is our rejoinder submissions. We say, unfortunately, the defendant misunderstands the claimant's case. At paragraph 2 of its submissions in reply, the defendant states that the facts are neither unprecedented or remarkable, and that there are scores of cases dealing with precisely this state of affairs, i.e., where the judicial officer is, for one reason or the other, unable to complete a hearing, and another judicial officer is required to act. With respect, that's not the claimant's case. The claimant's case goes far beyond such a simplistic description. It is obvious that the defendant from the onset has been trying to downplay the exceptional facts and profound impact of the case. There are no cases which precisely deal with the claimant's case because the claimant's case is unprecedented and unique. It's not simply a case where he wants to have a legal advisor of his choice who is experienced and charges high fees. That's not the case. This is not a case in which a learned magistrate died or the matter was starting de novo. This is not a case where it was discovered during the course of the proceedings the magistrate was unsuited to hear the matter and the matter had to be started de novo. This is a case in which an organ of the state is wholly and solely responsible for the PI having to be restarted. This is a highly conceptual and intellectual distinction that puts the case in the higher echelon of legally uncharted waters. And at page 107, at paragraph 5, it's therefore readily apparent from the foregoing that Buddha Singh wanted to emphasize the distinction between offenses and murder which carries the ultimate penalty of death. We submit that the factual matrix of this claim is such that there was a breach of the right of protection with law and others. We haven't been charged with murder and having found funds to pay his lawyer of choice. Due to the state's own fault, he now has had to resort to having money to pay his lawyer a second time. This is the context of a man who cannot get bail, and the sum total of this is a breach of his constitutional rights. So, my Lord, the way the case was put, it's not fair to pluck and treat in isolation the issue of the legal fees alone. It was about a breach of his fundamental rights, and the right which was eventually found to have been breached was the right of protection of the law. That is what it concerned. Can I take you to page 100? At paragraph 5. To show you where this concession was made on the facts. This is the state's submissions in response. And at paragraph 5 it says, apart from the one-sided slant with respect to the background facts in this matter portrayed in paragraph 8 of the claimant's submissions, the defendant takes no issue with the actual facts stated in that paragraph. So paragraph 8, which I took you through with the Roman numerals, that is their position in response to it. They take no issue with the facts stated in that paragraph. And then I take you to the affidavit in response at page 704.
Could you give me that page again?
704.
Thank you very much.
Much obliged, my lord. And this is their affidavit in response. It comes from a legal counsel in the Ministry of the Attorney General. And in paragraph 4, they say this. In this action, the claimant alleges that the Attorney General violated his constitutional rights as a consequence of the state's failure and or refusal to pay for counsel of his choice to represent him in the second preliminary inquiry, which he says has been occasioned as a result of the failure and or conduct of the judicial arm of the state, which resulted in his first PI being heard de novo. The idea that they did not know the case they had to meet rings hollow in light of this clear and explicit statement in their own affidavit evidence in response. And the Court of Appeal paid no regard to this. The Court of Appeal bases its judgment on the fact that there would have been prejudice and unfairness because they did not know the case they had to meet. And here it is, early on in their affidavit in response, they put it as clear as could be. They understood the case they had to meet. And in paragraph 8, their response to that case was, they advised by counsel that having exercised that right, it is incumbent on the claimant to ensure that those by whom he wishes to be represented are put in funds within a reasonable time before the trial, and if such funds are not forthcoming, to apply in advance for legal aid. A man is in prison for 7 years, and as a young man, and the position of the state in response to his constitutional claims, he said, well, he needs to put his lawyers in the funds. Where's he going to get it? He comes from a poverty-stricken family in Trinidad. And at the top of page 706, paragraph 9, they say that faced with a PI in respect of a charge of murder, of which he had ample notice, does not take reasonable, and if he doesn't take reasonable steps to ensure that he is represented at the PI, whether legally or otherwise, he cannot reasonably claim that lack of representation has resulted from a deprivation of his constitutional rights. And then they say he can go to legal aid, Hewering Law School, Lord, we've put an affidavit response about the state of legal aid in Trinidad, and these are, the commentaries about it come from even the state itself about its inadequacies and shortcomings. But this is a man who faces, potentially the death penalty if he's convicted. Hewering Law School runs a legal aid clinic with law students. Law students.
It's fair to say, isn't it, that in a way, the way that you were putting it might be said that your primary case was that you were seeking to establish a breach of a constitutional right that would have led the state to have to guarantee up front that there would be funds provided for adequate or a counsel of your choice, of your client's choice. That seems to me the direct way in which you were putting it, but we've then got what looks like what you might call an indirect way of putting it, which is that while the state may not have to provide funds up front, if you go ahead and then incur the cost, you're claiming that as compensation for the breach of the constitutional right.
Yes.
So really, the other side are saying to you, your sole case was the direct claim, and they didn't really have proper notice of the indirect claim, and you're saying they were both there, both Correct. The direct and the indirect.
Correct, my lord.
Yes.
And I'm saying that because one has to locate this claim in the evolving chronology of events, including the ongoing process of litigation, starting with the application for leave and the judgment of Justice Rampasad, which I took you to, the judgment in the interpretation claim, in which a judge said, file a constitutional claim. It's better to be dealt with there. And then we file the constitutional claim. And my lord, if it's a constitutional claim, you can only get to the issue of payment if you establish a constitutional breach. There must be a breach of a fundamental right in order to get to the question of monetary payment via compensation. So I accept that that is of an obvious limb and way to look at it. But the point is, we also said that the interpretative lens through which the case must be viewed it had to do with the arbitrariness of the entirety of the process, and because there are higher issues at stake. The sense of public outrage, the manifest injustice, the oppression. These were matters, my Lord. The impact on public confidence. Those are the reasons that the judge went on to award vindicatory damages. This is not by any chance a run-of-the-mill case. No one is arguing that if a magistrate dies and you have a de novo hearing, the state should pick up the tab. No one is arguing if someone takes a bias application to have a magistrate recuse themselves and the ground for the bias is discovered when they're about to deliver judgment, that is a reason that you should have to repay, the state should pay the fees. No one is arguing that. We are arguing in an unprecedented case where the state, by its own machinations, maladministration, negligence, recklessness, misconduct, whatever term we use, the point is, he exercised his God-given constitutional right to instruct and retain counsel of his choice, and he was disabled from enjoying and reaping the benefits of that. That constitutional choice he exercised was frustrated, and he was disabled because of the machinations of the state. And that is how the case was put in the context of, the entire public. Very sure. Yeah, and my letter from Mr. Pennington reminds me that in the context of a case that lasted for 5 years, the first preliminary inquiry, to suggest that you bring a new lawyer on when you're seeking to gain your freedom and expedite matters, it's a non-starter. In fact, it was thank God we filed these proceedings, because Mr. Sturge remained in the matter, and the case, he got off on a no-case submission. So, there was no objection in the court below to a pleading point. No pleading point was taken. No objection in their submissions to saying, well, we don't know what the case is in the High Court. No such objection was taken. And then we go now to the judgment in the High Court at page 126. And I'll take it.
Can I,
sure, certainly,
by way of encouragement, just point out that you're slightly, I think, more than halfway through your allocated time.
Thank you.
We're still, I think, quite deeply in the first issue about the pleading point. And there's some quite important stuff to follow,
of course,
on which we will very much want to hear your submissions.
I'm obliged, my Lord. So, my Lord, at page 126 to 129, these are the relevant paragraphs.
And can I just also say, and having in mind your vocal issues, which are still very clear, you can ask us to read things without always having to read them out.
Oh, I'm not.
Or even asking your junior to read them.
I'm deeply grateful. My Lord, that's very helpful, Lord.
It's tough on the public who may be listening on the feed, because they can't see the documents, but we do it all the time.
My Lord, I'm very grateful to you. My Lord, I would ask the board to look at paragraphs 44 to 53, because that's really where we say the ratio of the judgment is located. And paragraph 47 is the troubling paragraph, the paragraph that troubles the Court of Appeal. Perhaps I can take it up briefly from I'll take it from paragraph 44 and 45 briefly. The judge says the issue is whether the claimant was treated fairly by the state. He says that what has to be considered depends on the circumstances of the case, and whether there's been a sequence of events that are so egregious that it would be unconscionable for a court to countenance the claimant's suffering as a result of it. And he says, because he understands the case, that, look, I'm careful not to cast blame at the bottom of the page on the foot of any person as to why the then Chief Magistrate was allowed to demit office without first putting things in place for parties. And then he goes on to say, however, so The judge says, I understand that I can't cast blame on anyone. And then he says, well, however, as though it's a ruminating thought, obiter dicta, what I find disturbing, whatever was said or not said by the Chief Magistrate, there was nothing done by the JLSE to ascertain what was the status of parted matters before the Chief Magistrate and the measures that have been put in place. There was nothing preventing the swearing in of the magistrate to be put off until the parted matters were completed. I find the JLSE had a duty when persons are appointed to ascertain position. And he says in paragraph 48, therefore in the narrow circumstances of this case, the cause of this, to be clear, if the protection law is breached, to be clear, the breach has only occurred because the cause of the second hearing was due to the fault of an arm of the state in not ensuring that proper measures were put in place to ensure that parted matters before the then Chief Magistrate were adequately dealt with before she demitted office and was elevated to the High Court. At the bottom of the page he says, it is the culpability of the state in this matter which has led to the breach. Not the culpability of the JLSC, but the culpability of the state. And Lord, since Maharaj and the Attorney General with Lord Diplock, the state includes and personifies the judicial officers, the Judicial and Legal Service Commission, all of the state's agents. So they're all part of the state in the eyes of the Constitution. And that's the judgment. And then damages, my Lord, I'll leave that for my Lords to read themselves. I don't need to go to the Court of Appeal judgment. I think the court, I would take it that the board has read that, and I've made my commentary on that already, that the pleading point as the lone basis for dismissing the claim was wrong, that they erred in viewing the affidavit in isolation without reference to the fixed state claim. Can I now take you to the law? And I'll start by going to a case of Crane and Bernard at page 10, it was decided in 1991. It starts at 1075. I'll go to 1080. And at the bottom, this is a case involving, incidentally, the JLSC, Judicial Commission. And the court was faced with a situation where nothing much was said by way of response in this matter. And you'll see that if you go to page 1080, about the third paragraph from the bottom. As stated earlier, the evidence in these matters comes from affidavits of the appellant, to which they exhibited several documents. Pierre's affidavit did not, apart from one immaterial item, contradict the evidence of the appellant. And I say here there was no contradiction of the relevant facts in our case as well. And then they said the appellant was not cross-examined, and they cite the House of Lords judgment in Harrington, which is to the effect that you can draw adverse inferences if there's no evidence, if there's no cross-examination. And then they say, further, it is now the clear duty, and this is in 1991, it is now the clear duty of a public authority to assist the court by bringing forward in judicial review proceedings, and I will think in constitutional matters also, all facts and matters which are relevant to the determination of the issues. It is not that the appellant has a right to have them disclosed to him all information relevant to the decision which is seeking to impugn, but rather that the court is entitled to have this information divulged to it so that they may do justice to the parties. And he cites the well-known case of ex parte Huddleston from England, where once you can satisfy a public law judge, sufficient to entitled to apply for judicial review, it becomes the duty of the respondent to make full and frank disclosure. In proceedings in judicial review, there is no axe. The applicant no doubt has an axe to grind, but this should not be true of the public authority. And they go on then to cite ex parte Cunningham, a 1991 case from England again. And my Lord, all it speaks to is the duty to make full and frank disclosure, which I'm sure the board is familiar with. But the point is, we say that the scale tilted. We had put enough as the claimant, and the scale tilted, and that duty to make full and frank disclosure and give a substantial and meaningful response arose and the state sidestepped it. And having sidestepped it, they then seek to complain about, well, we didn't know what the case was. And then I take you, my lords, next to, I'll just give you the references at page 205, but the Court of Appeal in its judgment.
So page?
Page 205. The Court of Appeal actually at page 205 commented on the state's evidence. And perhaps I can just briefly take you to, my lord, to show you what they did say about it. They recognized at page 205 in paragraph 37, they said, in the course of perusing the submissions of the Attorney General, we observed that the affidavits filed in opposition to the claim had little more than submissions of law. And we wish to point out that affidavits are written evidence and should not contain legal arguments or submissions. Now, it had little more than submissions of law. No facts, no evidence in response. And the court, having made that observation, they then don't actually go on to deal with what's the consequence of that? What's the legal consequence when the state remains silent, sidesteps the case, and doesn't provide any answer in response? Is it not the well-established principle that adverse inferences are to be drawn against such a party and in favor of the claimant? But that wasn't the case. And then on the pleading issue, we say even if there was a problem with the pleading, I take you to 1159, to show you that in public law matters, one can't approach such matters with a sense of technicality. This is the case of Barnsley, and it's Lord Denninger's then Master of Rules, and he says at letter C, at page 1159, Counsel for the Corporation said these two matters, which I have mentioned, the presence of the market manager, and the excessive penalty were not mentioned in the grounds when he applied for certiorari. That's correct. But I think he should still be able to raise them. It must be remembered that in applications for certiorari, the applicant knows very little of what has happened behind the scenes. That's us. He only knows that a decision has been taken which is adverse to him, and he complains of it. His statement of grounds should not be treated as rigidly as a pleading in an ordinary civil action. If the divisional court grants leave as it did here, the practice is for the respondent to put on affidavit the full facts as known to him. The matter is then considered at large on affidavit, and if there appears to be other grounds on which certiorari could be granted, the court could inquire into them without necessarily being bound by the grounds in the original statement. Can I take you to page 1170 next? My Lord, this is in fact the position in Trinidad. This is a judgment from the Trinidad High Court of Justice C. Prasad.
I beg your pardon, could you give me the page again, please?
1170. 1170.
Yeah.
And this is the case of Omati Lyder versus the Attorney General. It had to do with the wrongful execution of a search warrant on a media house, I think. But this is what the judge says at paragraph 16. He says the resolution of issues in this case does not hinge upon heavily disputed facts. Same here. And all the information as to the wording of the warrants is evidently before the court. And the judge may grant any relief as appears to be justified based on proved facts and so forth. The court, when faced with matters which involve the Constitution, should exercise a measure of flexibility, mindful that it has the right to intervene in furtherance of its obligation to guard against constitutional violations. Procedural rigor should not trump the need for constitutional vigilance. And in matters where the vindication of constitutionally entrenched rights is at play, the court should resolutely focus on substance as opposed to form. Accordingly, the jurisdiction of the court in this case, given the serious issues of constitutional importance which fall to be determined, cannot be restricted to the grounds outlined in the fixed state claim form. The established adduced evidence should ultimately fashion the applicable relief. Consequently, the claimant's submissions in relation to the offence of tipping off, etc., and then he goes to Talpada from the English court, where and he highlights the relevant part from Lord Justice Singh, which states that public law litigation can't be treated in the same way as ordinary civil litigation. And where he says, in particular, procedure must not become the master of substance, where, for example, an abuse of power needs to be corrected by the court, etc. My Lord, this, and in paragraph 22, the judge concludes, this is a matter involving significant public interest element, and there is need for comprehensive examination of the facts and the law to determine the constitutionality of the process. The court will not genuflect to overly technical procedural arguments, disregard matters of substance, or abdicate its obligation to fearlessly defend the Constitution. The court shall consider the issues raised. Now, Lord, I commend this as the correct approach to take, which the Court of Appeal didn't. This is what will fulfill the objective of vindicating the rule of law. My Lord, I go now to protection of the law. My Lord, it is not our case that every case involving abuse of power, arbitrariness, unreasonableness, or fundamental unfairness will necessarily lead to a breach of protection of the law. That's not the case. As the board said in CPC, there must be a minimum threshold that has to be crossed to trigger the breach of the constitutional right. There must have been, for example, some identifiable loss. There must have been, for example, real and substantial prejudice and serious consequences. Now, it's impossible for one to exhaustively give a definition, to establish, as it were, exhaustive criteria. But, my Lord, as a young, functioning, maturing democratic society, Trinidad and Tobago and the Caribbean, as former colonies that have attained independence, we have been trying to fashion remedial powers, innovative remedies to meet some of the growing teething problems and growing pains that are that would be associated with that kind of transition. And the right to protection of the law has been an important bulwark for us in the Caribbean. Because whilst I see in the UK, there is discussion by the Law Commission as to whether or not damages should be, the court should have the power to award damages in judicial review. Of course, that's not been accepted by Parliament as yet. But the discussion is an interesting one, because in the Caribbean, some of the problems that are unique and peculiar to small countries, with problems that are unique to them, we can only devise solutions under the shelter of the Constitution, which this board in Ramanuk said. The concept of redress, which is the word used in section 14 of the Constitution, that concept of redress is the widest possible source of remedial jurisdiction and power for the Supreme Court in Trinidad. And that is why the board found a way. It would have been nonsensical to say you can get exemplary damages at common law, but under the Constitution, you could not, you would fall short, as it were. And that's why the board, the concept of vindicatory damages, the board said, focuses on the need to, when public confidence is eroded, there's to vindicate the right, highlight the importance of the right, the egregious nature of the breach of the right, and all of those things. Now, my Lord, what we see is that in CPC, and in fact, in CPC, which is a recent judgment of the board, and I'll take you to at page 1237 now. And it starts at 1237. You'll see the section 4B ground, which is protection of the law. Mr. Stevens, at paragraph 47, page 1238, at the bottom. Mr. Stevens, responding, characterized the failing of the state as administrative in nature. He submitted that having regard to significant matters of overlap between 4A and B, the latter provision was not engaged in either appellant's case. His alternative submission was that adequate protection of the law was available by access to the court in a combined judicial review and constitutional claim in pursuit of remedies, which he contended were sufficiently prompt and efficacious. Paragraph 48, letter C. They're reviewing Mr. Stevens relied on a judgment of this board Lord Mance delivered in Central Broadcasting Services. And what the board said at C, it is in that context the judgment of the board stated that Section 4B is directed to equal protection as a matter of law and in the courts. And D, he said Lord Mance was not purporting to formulate an exhaustive statement of the protection of the law. And the same was in Bagwandine. They cite MacLeod. MacLeod has been used as the seminal authority from the board to say that protection of the law means access to the court simpliciter. That was an undefended appeal, and the board reminded us at the bottom of the page, paragraph 49, that Lord Diplock expressly declined the invitation in MacLeod and said that the protection of the law, it declined the invitation to supply a comprehensive definition of the expression protection of the law and do reference to what was said in Thornhill, in parenthesis, though not necessarily exclusively. At paragraph 51, the board noted, in so deciding, the Caribbean Court of Justice expressed the view that the protection of the law clause is of wide scope. The court opined that Lord Millet's formulation relating to due process in Batiste and Thomas was equally applicable to the protection of the law. They found support in Lewis and Jamaica. Interestingly, all of these cases to which the judgment refers were in essence concerned with procedural unfairness. However, the judgment read as a whole, the court was clearly espousing a thesis that the reach of Section 4B is restricted in this way. It was clearly not espousing. It was meaning to, and then they go through the Maya Alliance leaders case. The board proffers a summary. I'll take you to Roman numeral 3. While this right has been traditionally considered to guarantee access to courts and tribunals, which are independent and impartial, the court considered this an unduly narrow interpretation. The right of protection of the law encompasses access to and enjoyment of the fundamental rules of natural justice. It goes beyond the issues of access to judicial or quasi-judicial proceedings. It is a broad spectrum right. At 53, the law is in a state of evolution, but we may make the following observations. It is a multidimensional, broad, and pervasive constitutional precept grounded in the fundamental notions of justice and the rule of law. The protection of law prohibits the government, which arbitrarily or unfairly depriving individuals of their basic rights, etc. I believe that for my lords to read. My lord, and then he says at paragraph 54, the most recent judicial learning on this subject of protection with law from the board is in Maharaj and the Prime Minister of Trinidad and Tobago, and he quotes Lord Kerr's judgment, where the central theme is said to be availability of an efficacious and timely remedy through judicial proceedings, and a breach will arise where the remedy cannot be or is not provided. A breach will arise where the remedy, the board considers those will be of some importance. The cannot be scenarios typically arises where the affected person has not initiated proceedings because no appropriate remedy is available. In contrast, the is not scenario will normally arise in a case where the person concerned has indeed pursued legal proceedings, in which event the focus will be on adverse outcome of an, or whether any remedy secured thereby was prompt and efficacious. Now, my Lord, I wish to correct something in the judgment for the record. Maharaj and the Prime Minister of Trinidad and Tobago was not, in fact, the most recent judgment from the board that dealt with protection of the law. Maharaj was, in fact, there was a Jamaicans for Justice case. The CPSR judgment was dated the 24th of May, 2021. But Maharaj, you see, is a 2016 judgment. But there was a pretty major judgment for us, which was delivered by the Board of Jamaicans for Justice. And can I take you to page, and that was on the 30th of January, 2019, and it's to be found at page 1580.
1580?
Yes, 1580. And can I just take you quickly to page 1580 shows it was delivered on 25th of March, 2019, and I take you to 1589. Paragraph 22. And this is Lady Hale speaking for the board, a unanimous judgment. The Caribbean Court of Justice in Nerve, when construing Section 11, begins with which also begins with the word whereas, held that this did not mean that the section was merely aspirational or a preliminary statement of reasons which may make the passage of the Constitution or sections of it desirable. It was intended to have the force of law. The court went on to say that the right to protection of the law affords adequate safeguards against irrationality, unreasonableness, fundamental unfairness, or arbitrary exercise of power. It echoes what they said in Maya Alliance, which in turn relied on Boyce. This is what the discussion by the board said at paragraph 24. The board is also disposed to accept that the right to equality before the law, like the right to equal protection of the law, affords every person protection against irrationality, unreasonableness, fundamental unfairness, or the arbitrary exercise of power. There are, in any event, fundamental common law principles governing the exercise of public functions, as there is nothing in statutory framework governing the PSC to contradict them. They are applicable in this case irrespective of whether or not they have had the state of a constitutional right. So, my Lord, that's the position from the board. There was another judgment that was missed in CPSAD, and it's a case of Oswald Alleyne. And that's the one we emailed this morning to the board. I don't know if my lords have it. And in Oswald Alleyne, I'll just give you the paragraph references, my lord. It's paragraphs 23, 27, 30 to 36. And the reason I refer to that judgment is because of the submission my learned friend makes, that there's a pushback to these developments. These are hard-fought for gains. We suffered under the judgment of MacLeod and the Attorney General. We suffered for a long time, for decades, with that judgment, because it said it's about right of access to the court. Once you have right of access to it, and the fact that you were before the court complaining about a breach of the right of protection of the law was incidentally illustrative of the fact that you were exercising the right of protection of the law, because you were before the court. And these gains that we've made took a long time, and we've gotten the judicial endorsement from the board. But the pushback from the state is, well, look, administrative inefficiency and misconduct and negligence on the part of the state. Well, if you translate that into a breach of a fundamental right, well, I mean, that could create some serious problems. But, my Lord, we've been with the revolution and protection of the law, we've been administering it without any. The state hasn't been bankrupted. The judges are sensible. They take a practical approach, and there must be some minimum threshold. I mean, the public law, you have two mutually exclusive circles: judicial review, administrative law, and constitutional law. But there's a point of intersection. And where there's that point of intersection, where there's a degree of overlap, which triggers the sanctity and protection of the Constitution, the courts cannot shirk from its responsibility. And what we say, my lord, is that in CPSAD, the board said, look, the consequences must be serious, and there must be serious prejudice. Those are the exact words they use in CPSAD. So, for example, my lord, in Trinidad...
so where are you referring to?
In CPSAD, my lord. One second, my lord. If I take you back to 1241, let me just see if I can find it, my lord. Let me lower down. Yes. If I take you to page 1243, says the board considers, that's paragraph 62 at the bottom of the page, whether the right to protection of the law was violated in this case. The board considers that in any case where the court is required to determine whether there's been a breach of the right of protection of the law under 4B, it is necessary first to identify and then evaluate all material facts and considerations. Material in this context denotes those matters which have a bearing on the question of whether the right protected has been breached. This will be a fact-sensitive and case-specific question. And then at paragraph 69, so that's the best the board gave. It's because, I mean, by definition, you want to keep this a flexible concept, like proportionality or the man in the Clapham omnibus. 69. Next, it is relevant to consider whether the executive offered any defense of or justification for its conduct. Well, here, they didn't. There was none. The short affidavit sworn by the government official in the judicial review proceedings outlined a brief timeline of what was done, but not why.
You were telling us that there was a reference to serious prejudice. That's
there is, my lord. I'm sorry, 1 second.
I think it's page, para 72, isn't it?
72? I'm grateful, my lord.
1, 2, 4, 4.
Yes. Oh, yes. Yes, it's 70. I'm grateful, my lord. Yes. He says, at paragraph 72, the factual dimension of the relevant acts and omissions of the executive concerns the resulting adverse impact on the two appellants. It is no answer in this respect that the domestic courts ultimately found that they had not suffered cruel and unusual punishment. That is not the acceptable or applicable benchmark in this context. Indeed, resort to presumptions is unnecessary given the extensive evidence before their lordships of the appellant's conditions of detention and the assessment of Justice Cockram. In short, as regards children, the consequences of the executive's conduct cannot be dismissed as trivial or technical. They were rather real and substantial. So that's where I...
Okay, that was on the facts in that case, but what do you say has to be shown to establish a breach of the protection of law right in the context of this case?
Yeah, well, my lord, I say, my lord, it has to be the arbitrariness must reach a threshold that causes serious prejudice with serious consequences. As to how that will would manifest itself, I seek shelter in paragraph 62, where we are told it is a fact-sensitive exercise, and you'll have to evaluate all the material facts on a case-by-case basis. But I do say this, my lord, by way of some clues might be, for example, is there an identifiable loss? Lord, we have used protection of law, for example, in the case of Patrick Awong and the Attorney General in Trinidad, a case I was involved in recently, where a fixed penalty ticket was paid by a citizen, but the state did not cancel, make note of the payment on the system. And as a result of which, after 14 days, a warrant was issued. The person was arrested, proclaimed that they had already paid it, but they put them in prison.
Do you mean identifiable pecuniary loss?
No, that's why I'm using this example. The loss need not be pecuniary. In this example I'm citing, the person lost liberty.
Right.
In C. Prasad, they lost the right to liberty. One can also see, for example, in a planning case, for example, or a compulsory acquisition case, you may lose the right to develop your property. That's actually an example cited by the judge in the judgment in this case at first instance. Can I take you, for example, to a case of in Oswald Alain, my lord, before the board. That concerned a case where there was a delay in making regulations that should govern municipal police officers in respect of the collective bargaining process. And the argument put before the board was administrative inefficiency should not result in a breach of the right of protection of the law. And even if it did, there should be no damages. The board rejected that. And the board said this was a case where right hand knew what left hand was doing, but neither did anything about it. And as a result of that maladministration, the board upheld the declaration for breach of the right of protection of the law, and also reversed both courts below on the issue of damages and said the vindicatory damages would be in order.
Could you tell us where that case is?
Certainly, my lord. It's the one I emailed this morning, my lord.
Oh, it's this morning.
Yes, sorry. And I've given you the paragraphs 23 to 36.
It's in our share.
Thank you.
But that's a case where, there was no identifiable loss, but in the sense of a pecuniary loss directly. But you know that the prejudice was immense because they would have lost out in the collective bargaining process for a number of years. And again, my lord, what the board said is that one has got to focus on its role in vindicating and upholding the rule of law. So, my lord, whilst there may be factors, it's difficult to give an exhaustive criteria. And I think that's why the board in paragraph 62, proffers that formulation, as it were.
But so far you've given us, what you're being asked is, tell us what you say the factors are here that means that there's a breach of the constitutional right. As I understand that you've so far said to us, well, it's an arbitrary decision that's caused serious prejudice. So is it the seriousness of the prejudice that you're really focusing on?
Yes, I think it's the seriousness of the prejudice and the consequences.
Well, that's one and the same, isn't it?
Well, sure, my lord, yes. The prejudice and consequence here was this. The first PI was nearing completion. The man obviously had to spend more time in prison as a result of the delay that would have been occasioned by the de novo order.
Do we know that?
I'm saying it's a reasonable inference that you ought to be able to make on the facts, because the state filed an interpretation claim. They didn't know what to do. The DPP made that inquiry in court. No one could say whether the chief magistrate resigned or did or not. So what happens with that uncertainty, in light of the DPP's letter to the Chief Justice and so forth, the state filed an interpretation claim. There's a delay as a result of that. And 2 years later, the stakeholders meetings, all sorts of things playing off, but then you have the second trial, and that starts. But one can only reasonably infer that had all things been equal, 60 witnesses, that the first PI, we said it was 90% complete, we said it was 90% completed, all things being equal, they would have finished in a reasonable time, and that the logical inferences, Mr. Charles's prejudice and anguish and frustration included a prolonged extra period in prison. It must be.
And you're not able to help us with what you're suggesting that prolonged period actually is?
Well, no, I can't say with certainty, because remember, I can't predict, as to when the first PI would have been completed, but we do know he got off on an OK submission. And if the second PI is anything to go by, well, it shouldn't have been long again. But look, in Sam Mirage, before this board, the board was at pains to say that to reject the argument that speculation in assessing damages or identifying a period of a specific loss is not a deterrent to the breach of the right and the assessment of the damages.
Can you just show us that, please?
Sam Mirage.
Yes, can you show us that?
I don't know if we have it in the bundle, my lord.
You do.
Is there? Yeah, sure. We have to Sam Mirage. 1946. Sorry? 1946. 1946. Thank you, Peter.
So the serious prejudice is the loss of liberty?
My lord, it's that plus, my lord, the mental anguish, the distress, the frustration that the appellant would have undergone. My lord, there was a riot that day in court. There was a riot because these are people who are seeing the light at the end of the tunnel after so many years in horrible subhuman conditions on remand. And then all of a sudden you're told, well, sorry boys, we're going to have to start all over.
Is there any authority that mental distress of that kind counts in this context?
Well, in Maharaj and the Attorney General, the board established that distress and inconvenience is in fact a ground for constitutional damages. So that's been long with us, that distress and inconvenience is a ground for constitutional damages when considering the breach of a right. And that's in Maharaj and the Attorney General. So if I can quickly to the, I'm looking for the relevant part to answer my Lord's question in Sam Maharaj. Sorry, my Lord, if you're finished.
Yes, so you've given us loss of liberty, the mental distress. Are you including any financial loss?
Yes, I said that one of the measurements of the financial loss would be the monies that he would have lost as a result of having paid his attorney the first time around and having to retain him a second time to do the second PI.
And what do you say that loss is?
$150,000. Which is roughly about 15,000. But 10 to 1 of those days. I don't know what's happening now with the pound. Yeah, but it used to be 10 to 1 at that time. So it used to be 10 to 1 at that time, my Lord.
So $150,000, and you say he lost that because there was a requirement or a commitment, an undertaking to pay it. Is that right?
No, I'm saying he lost that because he paid that money for the services of his defense lawyer in the first preliminary.
In the first
waste, if you like, of the original fees or the original fee, because you say due to maladministration, the whole of the first process ended up being aborted.
Yes, indeed.
Repeated. It's really a coincidence that the fee for the second process is the same as the fee for the first process. It may be a convenient one when it comes to quantification.
We treated it in the court below. I think the judge, if I'm not mistaken, the judge had made an inquiry, but it was a flat fee. Mr. Sturgis, I think the judge said in his judgment, Mr. Sturgis is a very he's an experienced practitioner.
Yeah.
And he said it was a fair and reasonable sum. That finding by the judge that the $150,000 was a fair and reasonable sum by a judge who is aware of what obtains in our local culture ought probably not to be disturbed by the board. I say it ought to be respected and accepted because that's, I mean, the first
but there is a difference, isn't there? Sorry to interrupt. But there's a difference between two ways of putting your case. One is it was the wasted costs of 150,000, or it was the actual new cost incurred because of the de novo hearing and the new payment that would be made. Now, as I understood it, it was the second of those that was the basis of the first instance judge's approach. But are you saying it's open to us to see it as rather differently based? That is, it's the wasted 150,000 first time round.
I think yes, it is open to look at it in that manner, yes. But either way, we say it's a distinction that will not yield a practical difference because that was the fixed fee that was charged for the second preliminary inquiry, and that was the basis upon which we proceeded in the courts below. And I think that the judge found that was a fair and reasonable sum for Mr. To cover the cost of the second PI, and there was no cross appeal. There was no appeal against that specific finding, as it were. So, my Lord, I think.
So the primary way you put it then is it to support the judge at first instance, or is the primary way you put it that we should decide if we're with you, otherwise with you, that it's the loss in respect of the wasted costs on the first PI? It's important that we understand the way you're putting your case and that Mr. Knox understands it too.
Well, I would say the first port of call would be, look, it really ought to be the costs thrown away. That would be I think that should be the first way to look at it because they've aborted the first PI, and all of those fees have gone to naught. And we have the receipts exhibited, so we know what he in fact paid. And the second, in the alternative, we say one can look at it as being the costs of the second PI, which he will have to meet, and which he was liable to pay Mr. Sturge, which the judge found was fair and reasonable in the circumstances.
So you said the judge found he was required to pay it, and it was a fair and reasonable fee.
Yes, the judge did, my Lord. There was no issue raised by the state that A, he did not have to pay that money, or that it was an unfair or unreasonable amount. And
Well,
in
except
fact-
that the state did say in their affidavit, well, he could have gone off and got legal aid.
Oh yes, they've said that, but they didn't take issue with that being a reasonable and fair fee for retaining Mr. Sturge. I mean, they did say he could go and get legal aid, but that's not saying that the fee was unreasonable or unfair in any way.
Yeah.
I'll come back to that, and that we don't accept that's how it was actually.
But we say, look, regardless of how it's put, and regardless of how one cuts it, twists it, or dissects it, at the end of the day, whether it's as a result of the costs thrown away or the same costs being the cost that he has to put out for the second preliminary inquiry, he sustained an identifiable financial impact, adverse impact. In High Court. Yeah, okay. Well, okay. So, my Lord, I was about to look at the Samara judgment, and I can take you to 1955.
Thank you.
It starts actually.
I think the speculation part comes from Elaine, doesn't it?
From Elaine, my Lord?
I think the bit about...
There was something in, I thought I remembered reading something in Sam Mirage as well. It might be in Elaine as well for sure. But it's 43 in Elaine, I'm told, and in Sam Mirage, I'm just looking. The discussion on protection of law starts at paragraph 37 on page 1958. And then
1961, paragraph 48, which is citing from Elaine. And 49.
Paragraph 49, my Lord? Oh, yes, 49. As was the case in Elaine, I'm grateful, my Lord. Thank you. As was the case in Elaine, the board in this appeal recognizes that there may well be difficulties in making the assessment of an appropriate amount of damages. It must be left to the local court, who can examine the circumstances to determine if and by how much the appellant should be compensated. Yes, and at paragraph 51, on that basis, it was claimed. What did this say? It's 48. The Court of Appeal had concluded compensation was inappropriate because any attempt to compute the appellant's loss would be mere speculation. The board roundly rejected this as a reason not to award damages, saying it is a general principle of common law that if an injured party can establish a head of loss, whether by reason of the wrongdoer's conduct, by reason of the wrongdoer's conduct, it is difficult to quantify. The fact that there may be many speculative factors is not a reason for denying the assessment. A monetary award under Section 14 is discretionary, but that is not in itself a reason to adopt a different approach. My Lord, I'm indeed grateful.
I'm so sorry, which paragraph are you reading from?
That's 48, my Lord.
48, thank you.
Yes.
Yeah.
And I'm grateful, my Lord, that is precisely what I had in mind, yes. So that, my Lord Burroughs, it deals with the inherent, the speculative nature of assessing damages for the distress, inconvenience, the frustration, and the ensuing depression that would no doubt, and the mental anguish that would have occurred. And one, in his mind, he doesn't know how long the second PI will take and how long it will take to resolve. So, my Lord, now the award for vindicatory damages, I say in Ramanup at page 1206. My Lord, I intended to just refer you to a case of Candice Greenwich, and I didn't. What page is Candice? What page I wanted to cite on Candice Greenwich? 14. Yeah. My Lord, this is at 148 on a case of Candice Greenwich. We've put before you, my Lord, a few cases where protection of the law was found to have been breached. And this is one such case. And my lord, the relevant page number, what? 1497. Thank you. Yeah. I mean, this was a case, my lord, where a teacher had done a degree at the government's prompting to get promotion in the teaching service. Having done the degree, the Ministry of Education had problems with the degree, having encouraged and represented that this was the way to get promotion. And the delay in assessing that degree put the teacher at a great disadvantage. So at the top of page 1497, the court said, look, there was no evidence put forward by the second respondent accounting for this lapse of time. And in my view, it was completely unjustifiable. The question of whether the CPO should accept the recommendation, a matter which should take weeks or months, is a matter which should take weeks or months, not years. Further, the evidence, it appears that the second respondent paid little regard or little or no regard to the matter until it was prompted into action by officials. The question which arises is whether the delay is sufficient to find that there had been a breach of the constitutional rights, my alliance. The result of the unreasonable delay is that persons who may be waiting for a state or government body to take some action or may make some decision in order to proceed with their business or profession may suffer loss as a result of such action. An example which springs to mind is the granting of approvals to build town and country planning or municipal corporation. If these bodies take too long to deal with applications, developers and homeowners could suffer loss either through having to mobilize or demobilize construction or having to seek alternative accommodation or lose a business opportunity. Such a result would, in my view, be fundamentally unfair. Another example would be where a person makes an application for a scholarship and the body in charge takes too long to make a decision. It would be fundamentally unfair to the applicant because the opportunity for the scholarship may have passed by the time the decision is made.
But one has to be rather careful. That's rather broadly put, isn't it? There are all sorts of circumstances in which delay in decision-making results in a loss.
I accept that.
Do you say they all result in a claim for damages?
No, they can't all, my lord. I mean, they can't all. That's why I attempted earlier to say there must be substantial prejudice and serious consequences, which is the formulation in CPS by the board in CPSR. It's not every case of administrative inefficiency or maladministration that will take it outside the realm of a claim for judicial review and cross over on the doorstep of the Constitution. No.
And how one decides which side of the line it falls? Is it just a question of judgment?
I think it will be, my lord, but over time, as the jurisprudence develops, as with so many other concepts, there would be principles that will emerge. I mean, we've set forward, my lord, 4 different categories that we say emerged in our reply note, which you will find at page. We were able to identify 4 categories, and it's at paragraph 11. It begins at 994 and paragraph 11.
Because I think you hang your hat on the 4th one. And you hang your hat on the 4th one.
Yes, we do. That's right. So we've been able to distill these 4 categories, and we say we fall on the 4th one.
Yeah.
So, my lord, I mean, the ebb and flow of judicial activism on this is something that is very precious to us because it gives us it gives the judiciary a certain measure of flexibility to deal with innovative situations. But it's not, my lord. The short answer is no. It is not meant to be a runaway horse. And, my lords, indeed, it has not been. In fact, I've cited 3 judgments and 2 from the board. But other than that, there aren't that many that have crossed the Rubicon. So that the judiciary...
You may say, and I think you do say, that this is an extreme case, but if you're inviting us to apply a principle, we must be conscious of the extent to which that principle can be applied in other circumstances.
Well, my lord, the best I can do, my lord, is to say this. Where there is arbitrariness to such an extent that it causes substantial prejudice with serious consequences, then it violates the right to protection of the law. And the arbitrariness must result in some form of fundamental unfairness that arouses judicial conscience and crosses the line almost into a sense of public or judicial outrage at the conduct.
But is arbitrariness really the right word to describe what happened here? It's more, wasn't it, a level of incompetence on the part of those responsible for making the appointment of the Chief Magistrate to the High Court bench?
Well, in Jamaicans for Justice, the way Lady Hale put it, she said it's irrationality, fundamental unfairness, arbitrariness, and of course maladministration. So it may very well be that this falls under
yes, I mean that's
maladministration.
in your subparagraph 4 in your reply case, irrational, unreasonable, arbitrary, or fundamental unfair.
Yes.
So this might be said to be unreasonable, but there has to be a level of unreasonableness, doesn't there, before it engages the constitutional rights.
I said arbitrariness because there must be some certainty in the conduct of the administration of criminal justice, because you're dealing with people's liberty at the end of the day, and not knowing whether the Chief Magistrate resigned, not knowing whether they're going to continue and she's been brought back on the bench, and if she's been brought back in what capacity. Everything was up in the air. It's the height of arbitrariness. Look, this case, I'm not asking you to go beyond the boundaries of this case. This is an exceptional case where we say on the facts, whatever formulation we use, it breaches the right to protection of the law. But it is a unique case.
Do we know what happened to the other cases?
I'm not, I can't say for sure what has happened to the case, but I think they've all been dealt with. I think they've all been dealt with, yes. Because
well, it's one thing to say they've been dealt with in the sense that the preliminary investigations
the preliminary inquiries
to their conclusion, but have there been other claims for constitutional redress arising out of the 53 or 4 cases that have themselves been dealt with?
I don't think so, my lord. The question was raised with me in the Court of Appeal as to whether or not there were any other claims. I'm not aware that there are any other claims.
So you're not aware that this is in any sense a test case?
No.
Thank you.
In fact, no. And in fact, my lord, this question, we had a discussion about it in the Court of Appeal, my lord. In the case that was cited in CPSAD, that is the case of Central Broadcasting Service. That is the case concerning the radio license award. And the appellant who succeeded in that matter, a question was, the issue raised by the state was, there were other persons who had been approved and were higher on the priority list to receive a radio license than the appellant. And the argument the state raised was, look, we have a limited bandwidth. Grant a bare declaration that the right to equality of treatment was breached, but don't mandate the state to give them a radio license. Lord Mance said in his judgment, he said, look, this is the appellant before us who has complained, and we're not to concern ourselves with those who didn't complain, and they mandated the state to grant the radio license. So it's a bit like, for example, prisoners' rights cases about prison conditions. All of the other prisoners may very well be entitled if you find the prison conditions as subhuman. But does it mean that is a deterrent to making an actual declaration on the facts before the board?
But it is a possibility that if we were to decide this case in your favour, there will be the other 53 may well fall into the same position, and may well therefore, as a result of our judgment, be able to bring a claim for damages. But you say that's just speculation.
It's speculation because, my lord, it may very well be that all of the others were able to afford quite comfortably a second counsel for the second PI, and that's why they didn't bring a claim. Mr. Akili Charles, as you will see from the facts, he was from particularly poverty-stricken circumstances and was a very young man. He was a youth. So that, I can't speculate about the others, but what I can say for the record, there is no other claim, there was no other claim brought by any one of the 53 persons who were affected. But I can't say why, but I do know that this appellant brought a claim because he could not have afforded it, and he was a young man who had been languishing in prison for a long time. My lord, unless I can be of further assistance, I think I've exhausted my time, and I'm very grateful to the court for the courtesies extended. Thank you very much.
Well, thank you very much, and your voice mercifully lasted out, Mr. Lodge. Yes, Mr. Knoll.
My Lords, I'd like to start just by making the 4 points in summary which I want to deal with. The first is I say the Court of Appeal was right, indeed plainly right, to say that the judge found for the appellant on a basis that had not been pleaded and indeed was not even in evidence, certainly not properly in evidence. That is to say, the Court of Appeal was right to say that there was no evidence or pleading that the JLSC was at fault and that it was the JLSC's fault which had brought about the need, essentially, for a second preliminary inquiry. Therefore, the Court of Appeal was bound to interfere. That's the starting point. The second point I make is this. This was an important error by the judge to find on this basis, because the appellant's case before him was not that the Chief Magistrate's elevation to the High Court bench before finishing the appellant's case of itself amounted to a breach of the protection of the law within Section 4B of the Constitution. Rather, I say on any sensible view of the appellant's case, it was simply that the State's refusal, given the need which had arisen for the second inquiry in the circumstances in which it had, to pay the sum of $150,000 for his legal fees for the second preliminary inquiry, that was a breach of the protection of law provision, and indeed of Section 5. That was his case. His case was put quite high, in other words. By not paying the $150,000 I need for the second preliminary inquiry, you are ipso facto acting in breach of my constitutional rights under Section 4 and Section 5. Likewise, his claim for vindicatory damages on a proper view has nothing to do with the claim for extended period of imprisonment. It was to do with his claim that he should have been, the State should have paid for his legal fees.
Is that part of your second point?
It's part of my second point, yes. So in other words, it's not open. What I say, it's not open for the appellant to recast his claim now before the board and say that the Court of Appeal should have dealt with his claim on a different basis. The reason I say this is important is that because of the way the case was put, there was no specific evidence addressed to two important points on which Mr. Ramley has been asked questions by your lordships. That is, first of all, was the State's fault so grave as to give rise to such a claim? Where does one put this on the scale of things? Was it at the top end, arbitrary, unlikely? To what extent was it incompetence or maladministration, and how much incompetence was there? The trouble is, because of the way the case was put, none of that was gone into. Secondly, the other consequence was that there was no investigation into the question whether or not, in the events that eventually happened, the appellant was provided with an effective remedy for the State's failure. And in particular, on the effective remedy point, the question which now arises in my submission on what I call the new case is this. Did the law provide a prompt and effective remedy? First, because in the event the appellant did not have to spend more money on his lawyers than he would have done had the first preliminary inquiry come to its natural conclusion. We have no idea about that. Secondly, we do know this, that the second preliminary inquiry was concluded very swiftly, so that the appellant does not appear to have had to spend more time in prison than he would have done had the first preliminary inquiry come to its natural conclusion. Therefore, the appellant's claim wasn't directed to these points, there's no specific evidence on them, and it would be wrong, in my respectful submission, for the Privy Council now to hold that the way the appellant put his case originally doesn't really matter, and allow the argument on the appeal, on the arguments now being advanced. My third point is this: in any event, on such evidence as you do have, it's not possible to say more than that there was incompetence or mismanagement on the part of the State by reason of the Chief Magistrate's elevation before she had finished hearing the appellant's case, preliminary inquiry, And one cannot characterise the state's conduct overall, taken in the round, as arbitrary, oppressive, or sufficiently irrational so as to bring it within a breach of the protection of the law. In particular, I do submit this, it appears that as a matter of policy, or pursuant to the policy, the appellant's second preliminary inquiry was given priority in accordance with the policy of the law. We know that sometime must have happened because it took only 2 months. And second, it is not possible, therefore, to say anything more than that you can't, therefore, say rather that if the first preliminary inquiry had come to its natural conclusion, the appellant would have spent less time in prison. And there is also another point, because I submit the real point in this case is this, which again isn't properly before you, but I submit does arise on the appellant's new case. It arises out of the question, what about the period of about 2 years from the time the de novo inquiry was, when it was announced there would have to be a de novo inquiry, and the beginning of the second inquiry? And one might say, well, what about that? What do we do about that? I can see that might be a point against me. He spent 2 years inside longer than he should have done. The difficulty with that is, it was that, and I'll show you the reference in a moment, that is clearly down to the appellant's decision to challenge the order that there should be a de novo preliminary inquiry. The delay, that 2 year, or more or less 2 year delay, is caused by the unsuccessful challenge. Because what the appellant wanted to do was to say in relation to the order for a second preliminary inquiry, was to say, oh, there should be no second preliminary inquiry, and I should be released now. That was what was going on in that period.
There was the interpretation summons going on. Surely you had to wait for that to be resolved.
No. I agree. You might say that, but no. What we do know is that the preliminary inquiry, other cases continued. I'll show this. It appears in the judgment. Other cases went on. In other words, other people didn't challenge the order, and they were continued to be prosecuted. And I'll come to that evidence in a moment. So in other words, other people's cases were heard in accordance with the order that was made in June 2017, and many of them completed by January 2019. And we can see that from one of the judgments you've been shown. But I'll come to that in a moment. That is an important point, I accept.
Does it tell them whether or not there's an effective cause? I mean, none of this would have happened but for the original problem.
There you go. Well, this is the problem. I accept one can argue that that's at the point that can well be put to me. The difficulty is none of this has been gone into in the courts below precisely because of what you might call very high way in which the appellant put his case. We haven't gone into it. There's no decision as to whether or not or no judgment, no argument below as to whether or not the appellant's decision to challenge the order for a de novo hearing was something that should be laid at his door or at the state's door.
Well, I can see if he'd simply brought a wholly unsuccessful application for judicial review, that might be one thing.
Yes.
But you, as it were, counterclaimed with your interpretation application, and they were ordered to be heard together, and the outcome of your application was, I think, was it not decisive of the appellant's judicial review claim?
Well, it's not quite. I think what happened was the DPP, it's not rather the AG, the DPP brought an interpretation somewhere.
Well, the state.
Yes. And he brought it first, I think. And then the appellant made his challenge. But there would have been nothing to stop the appellant, along with other people who were, as with the other 53 people or whatever, there was nothing to stop the appellant saying...
No, but the suggestion that the DPP thought that the point being raised was sufficiently uncertain to justify his independent application in the general public interest.
Yes.
Might be said to make it quite a strong thing for you now to submit, well, it was all the appellant's fault for bringing his judicial review application in the first place.
Not necessarily fault. Not fault, but the question is one of causation. Mm-hmm. Because what he was seeking to do, my lord, was the DPP wasn't saying, oh, people in the appellant's position should be let out. The DPP was saying, do we have to start de novo as opposed to carry on with the old preliminary inquiry? What the appellant was seeking to do by his judicial review claim was not to say, oh, I just want to carry on with my old preliminary inquiry. Far from it. What he was seeking to do is say, A, old preliminary inquiry out, B, no further preliminary inquiry, therefore C, I must be released. So it's not as if he was bringing exactly the same argument or the same claim or seeking the same relief as the DPP was. Now, my Lord, part of the difficulty is you haven't got all this before you, properly before you. If the case had been brought properly, as I would say, in the way that my learned friend now argues, all these points would have been properly before the courts below. You'd have judgments on them, and you'd be able to see to what extent one should attribute that 2-year delay to the state or to the appellant, whether it amounts to a protection of the breach of the law, and so forth. At the moment, you're not in a position to deal with that. And that, I submit, is the problem with the new way my learned friend puts this case. What you might call his best point, which is the 2-year delay point, I can see that's obviously a good point for him, has never been properly looked at, and quite why it happened has never been properly looked at.
You're going to come back to that when you... Yes. So that's your third point.
Yes.
Yeah.
And as to my fourth point, even if there was a breach of the protection of the law provision, the judge was wrong to order any damages to be paid. As to the sum of $150,000, there was no proper evidence that the appellant was put to any greater cost by reason of there being a second inquiry than he would have been had the first continued to its end, because we know that the second came to an end very swiftly on a no-case submission in just a couple of months. My Lords, I add a parenthesis here. It could only have come, presumably, to a conclusion on the basis of a no-case submission, on the basis that the evidence which had already been taken didn't give rise to a case in the first preliminary inquiry. So this wasn't a case of wasted costs in the first preliminary inquiry. All that material, and we've got it in volume 3, if you really want to look at it, but all that material had been taken, all that evidence had been taken, and presumably must have been used and put before the magistrate at the second preliminary inquiry to say, look, there's no case.
Well, we don't know, do we?
We don't know, but on the other hand, again, this is one of the problems of the way the case was put. But what we can say is that the evidence that was taken at the first preliminary inquiry was there. We've got it in the transcripts, and so presumably it was used. The presumption has to be that what happened at the first preliminary inquiry wasn't a total waste of time and money.
It must be pretty clear the basis upon which the no case to answer argument was advanced.
That would be that the evidence so far adduced
and
didn't give rise to a case.
And the only evidence so far adduced was the evidence in the first inquiry.
Yes, exactly. But all I'm saying is the money spent on the first inquiry of itself was not wasted because we've got all the material. Now, you might then say, okay, he got off at the preliminary inquiry, the second preliminary inquiry. As I understand it, if you are acquitted at a preliminary inquiry, you don't get your costs. That's as I understand it from Mr. Graham Logan. I might be wrong about that. But this was always going to be the position whether there was a first preliminary inquiry or a second preliminary inquiry. In other words, my lords, one asks realistically, the second preliminary inquiry, it seems, involved only 1 or 2 hearings. Well, the first preliminary inquiry was going to involve 1 or 2 hearings anyway, because the no-case submission hadn't been made in the first case preliminary inquiry. So one asks, in one sense, what is the difference between there being 2 preliminary inquiries, with one basically taking up all the evidence and the other, just the no-case submission, and just 1 preliminary inquiry? The answer appears on the face of it to be none at all. And that's why I say it's very difficult to see why, and I'll come to the evidence, why in fact any greater fees were incurred by reason of the order for a second preliminary inquiry than if the first had come to its natural conclusion.
But what about the alternative way it's been put? I understand your point about wasted costs.
Yeah.
You're effectively saying we can't say it's entirely wasted because it ultimately contributed to the way in which the case was finally dealt with.
Yes.
But then we come to the other way it's been put.
As to which, I say, my lord, the difficulty is there is no evidence that, in fact, it was agreed with Mr. Sturge that, come what may, he would be paid $150,000 for the second preliminary inquiry, and there's no evidence that the effect of there having to be a second preliminary inquiry was that he was charging for his 2 appearances in the second preliminary inquiry a fee which was greater than what he would have been charging to do the remaining days in the first preliminary inquiry. You'd have to have some sort of evidence to say, what was the global difference as far as Mr. Sturgis' fees are concerned? There's no evidence on that. Again, precisely because the case is put on the basis I'm entitled to $150,000 just like that. Without, as I said, the proper way of putting it would have been, I'm entitled to the difference between what I would have had to pay for the conclusion, to get to the conclusion of the first preliminary inquiry, and what I'm now having to pay. I accept that if the case is being put like that, then if one proves the breach of the relevant constitutional provision, then I accept. At that point, there would be a claim for damages. But until you prove the difference, you haven't proved anything. As to the claim for vindicatory damages, it just wasn't put. The way the case was put below was not, I'm having to stay in prison longer than I would have been, therefore I want damages. That, after all, would have been a claim for compensatory damages. I've been locked up for 2 years extra. The claim was put for vindicatory damages, i.e., my constitutional rights have been infringed because you didn't cough up the $150,000 when I asked you to. That's outrageous, therefore give me vindicatory damages. That was how the case was put. Now, what the judge did, in fact, was to say, I think you've obviously been inside prison for longer than you should have been, so I will award you vindicatory damages of $150,000. But I say that just wasn't open to him to do so, because that wasn't really the way the case was put. And he didn't have evidence before him as to what the difference was, how much extra time the appellant, if any, the appellant actually spent in prison as a result of the order for a second inquiry, indeed what the causes of that were. And that is why I submit, although one might say, just looking at the Court of Appeal's decision overall, that seems a bit narrow, I can see how one might say that. On the other hand, when you look at the recast case, there are all sorts of questions that arise which haven't been looked at properly at all, and which did require evidence and proper argument below, and which I submit with great respect to all lordships aren't in a position to deal with.
You didn't take any of these points below either. You didn't say there is no evidence of this is the way you got to put it, or anything really, apart from the fact you much to do damages.
Well, that's right, but we appealed on the basis that the judge had found on a basis which hadn't been put against us. That's enough in my submission. That was a perfectly proper way of appealing. And there wasn't, and many of the arguments now being raised weren't raised below, but that's a different point. I'm simply seeking to say that it's not open now to the appellant to recast his case so as to get round the lack of evidence, which I submit inevitably followed from the way he did put his case.
Again, your shows that, but you're saying it was put extremely narrowly on the basis that I'm entitled, the way the case is put is that I'm entitled to vindicatory damages because you didn't pay the $150,000
exactly.
Fast enough, or indeed at all.
Or you just refused to pay it,
Yes.
and you only offer me legal aid.
Yeah.
That, I submit, is the natural reading. And the one thing you haven't got is what you might call evidence, or argument to the effect that I have been kept in prison for an extra 2 years, and therefore I want damages. And one can understand why, one has said why they might not want to have argued that, bearing in mind the point I made a moment ago, namely, it was the appellant's decision not to get on with the preliminary inquiry, the second preliminary inquiry. Whereas if you had, then it may well have been as finished just as quickly as the first one would have been.
But if the appellant's case otherwise has merit,
Yes.
it appears to argue, not unreasonably, when the first PI came to an end and was told it had to start again de novo,
Yeah.
it already languished in prison for 7 years, and he was faced with the whole thing all over again.
Well, I accept that. I mean, my lord, that is so. My lord, it's not clear quite to what point that goes. The question is, was there a breach of the protection of the law provision? That is the ultimate question. And in my submission, you have to look at that in the round. And in my submission, there wasn't a breach of the protection of the law provision because the second preliminary inquiry was conducted very quickly. You then have this, what you might call this question about the 2-year gap between the order for a de novo inquiry and the beginning of the second preliminary inquiry in the appellant's case, as opposed to in everyone else's case, where it seems that everyone else has gone on with it. Now, that's why I say you're put in a difficult position by virtue of the way the case was put below. But I do also submit that, taking a broad view, it cannot be said that the appellant in this case was deprived of the protection of the law. The way I would put it in relation to the 2 years is that, sorry.
Does the evidence before the courts show that other defendants in the same position had second preliminary inquiries undertaken during that 2-year period? Because it sounds slightly odd that that would have been happening if at the very same time the Attorney General was bringing before the court a claim saying, I really don't know which way I should be proceeding.
My Lord, I'll come to the reference. It's actually in the judgment of Madam Justice Gopin, where she in terms refers to what was happening in other cases. And my Lord, it is noticeable it's only the appellant, it seems, who's bringing these claims. I submit that's not surprising, because everyone else succumbed, if I can put it that way, to the order for a de novo hearing, and the state then got on with it quickly, so that people were not prejudiced, at least in terms of delay, by the fact that they were facing a second rather than the first preliminary inquiry. But I will come to that one, which is a very important point, because that, if I may respectfully suggest, is really the point in the case. But even now, it's only just emerged in real life this morning before your lordships. It's not really my learned friend's case, but it's a point that obviously is live now, in the sense it has to be considered, but it's not really a point on which the courts below or the evidence below focused at all. So, my lords, I accept pleading points, narrow pleading points are unattractive when you can seriously say, but the evidence was all there, which would have come out even if the case had been put slightly differently. That's obvious. But if the evidence isn't all there, which would have been there had the case been put differently, then I submit it's not open to an appellant on a second appeal to say, well, look, you can look at it a different way, and on that way, I win. My lords, I just want to make 3 preliminary points. They more or less reflect what I say in our written case. The first is this. On the 4th of January 2009, Madam Justice Gopin dismissed the appellant's challenge to the ruling by the acting Chief Magistrate on the 1st of June 2017 that there would have to be a second preliminary inquiry. So the de novo order was made on the 1st of June 2017. Madam Justice Gopin dismisses the appellant's challenge to that decision. Therefore, in my submission, the premise on which this case must proceed is that it was lawful for the appellant to be subjected to a second inquiry. The mere fact he's subjected to a second inquiry cannot, in my submission, be said to amount to a breach of the protection of the law.
Well, no, but it's what, that's all very well if you confine your gaze just to the de novo order without looking behind it to see why the de novo order was needed.
Well, my lords, I accept that, or the consequences. But in my submission, if it was unlawful for the de novo order to be made at all, then Madam Justice Gopin's decision was wrong. But you cannot proceed on that premise. You must proceed on the premise that her decision, rejecting the challenge to the de novo order, is correct. There's no appeal against that.
No, certainly. But that's, if you like, just the doorway into the question whether that order became necessary because of a relevant breach of the constitutional right.
I agree with that. My lord, it's not a complete answer. I accept that. The second is this. It is plain that in Trinidad and Tobago that the policy of the law is that matters which are listed for a second hearing are given an expedited hearing by the presiding judicial officer. And can I ask you, please, to turn to page 120, paragraph 30. And this is the judgment of the judge of first instance, Mr. Justice Ramcharan. And you'll see it's the second sentence. At this point, the judge is talking about the claim, the appellant's claim under Section 5 of the Constitution. The claimants contend there's no procedure put in place to take into consideration or facilitate remanded prisoners when they have to face a second hearing. It's unclear what the claimant has in mind in making this submission, but it is to be noted that matters which are listed for a second hearing are by policy given an expedited hearing by the presiding judicial officer. So, my lord, I certainly don't accept what was said by Mr. Ram Logan, and certainly the judge doesn't seem to accept it, namely that you just go straight to the back of the queue. if in the case of the second preliminary inquiry.
I think Mr. Ramlogan was making that submission in the context of one of the authorities we were looking at and actually different situation.
Ah, well, my lord, there it is. In that case, I
I
apologise.
don't think he suggested that in this situation you went to the back of the queue.
Yes. Well, in that case, my lord, I withdraw the last comment. But it's important. There is a mechanism in Trinidad for dealing with this type of problem, because we're talking here about protection of the law. How has the law dealt with this in Trinidad? And I submit it's dealt with satisfactorily as far as the second preliminary inquiry is concerned, because that was completed in, it seems, 2 months. It began sometime in March 2019, finishes on the 20th of May. So there is no doubt that there was an effective remedy in the sense that the second preliminary inquiry finished within 2 months, and no one is suggesting that had the first preliminary inquiry continued to its natural end, it would have been ended even quicker than 2 months. No one's suggesting that at all. Apart from anything else, we know that a no case submission had to be made, and that hadn't yet been made at the first preliminary inquiry. Now, my lord, I mentioned Madam Justice Gobin's judgment, and I would like to take you to it now in this context, and it's at page 678.
I'm so sorry. 678, thank you.
And my learned friend, Mr. Ramlogan, I think, took you to paragraph 31 about travesty of justice. This is a travesty of justice and so forth.
Yeah.
And then paragraph 32, the JLSC is no longer a party to these proceedings. I hope it's not too late to offer some advice. And Mr. Ramlogan took you to the proposed advice that perhaps the JLSC should take on board. But then paragraph 33. To her credit, the current Chief Magistrate, that's say the replacement one, the current Chief Magistrate has managed with the help of her colleagues to complete several matters of the 53, and several others are now part heard. Having regard to the perception of the unfortunate claimant, it's my respectful suggestion that she should make good on her promise to consider refusal. In other words, she was going to recuse herself if the appellant's challenge for judicial review was unsuccessful. But the point I rely on is the first sentence. It's apparent from this that other cases were got on with. People didn't challenge the de novo hearing. My lord, I accept your point that, of course, the DPP at this point had put forward an interpretation summons, but despite that, it appears that actually other cases were going ahead anyway on the basis of the order that had been made. Because there was no stay, as I understand it, by virtue of the DPP's summons of proceedings that were otherwise being taken. And my lord, that's not totally surprising, because obviously it would be undesirable while the DPP's summons was being decided, which might take some time, for all these part-heard hearings to be held up. So again, I submit actually what the state of Trinidad and Tobago is doing, what you might call what the legal system is doing, was actually quite reasonable. They're getting on with it, and they're expeditiously. The problem in the appellant's case, as I've mentioned before, is he wants to knock out the second preliminary inquiry altogether, so he's released. And that is what takes the time up in his case. And you can see, I think, at paragraph 35, she does 34. I should draw your attention to this. Madam Justice Gobin says, I consider it wasn't unreasonable for the claimant to have filed this claim, i.e. to get to quash the second order, especially in the circumstances of lack of clarity as to the status of the former Chief Magistrate. Indeed, this concern was shared by the DPP, one of the factors which resulted in the filing of the interpretation summons. And then she goes on to award costs to the appellant, but only up to the stage of filing his fixed date claim form. And so forth. And all further costs could have been avoided had the claimant agreed to a stay of the proceedings to await the interpretation summons. That's a more cost point.
Well, if she's saying it's perfectly reasonable, or not unreasonable.
Not unreasonable.
Yeah, not unreasonable. Doesn't that negate your causation point?
Well, my Lord, no, in my submission it doesn't. Because what's being said against me is that the state of Trinidad and Tobago did not provide a satisfactory system of law to enable the appellant to have a more expeditious second preliminary inquiry. My answer to that is the second preliminary inquiry, which eventually took place, could have taken place earlier. The appellant made an unsuccessful and I would submit over-ambitious challenge.
But not unreasonable.
The question then is, how does causation lie in all this? I take the Lordship's point. I mean, one can say, well, it depends how you look at causation. It depends how you look at...
Well, normally you would say that if somebody acts reasonably, it doesn't break the chain of causation. That would be your normal principle.
My Lord, the trouble is that's Madam Justice Gobin's judgment.
Well, that's what you've taken us to.
Well, I agree. But I agree with that. But I've taken you for the facts, the basic fact. But if the claim had been put the way my learned friend now puts it, there'd be much more evidence on this. And we might know quite what the nature of the challenge was, how reasonable was it, and so on and so forth. I accept, my Lord, if as a way you take Madam Justice Gobin's judgment to be the same as the judgment, or you incorporate it into the initial judgment, then you might say, well, the point doesn't arise. The difficulty, my Lord, is I say that's unfair to the state, because it isn't the way the case was put against us.
Well,
I can see one.
we can see where we are. Mr. Knox, we'll resume at 2 o'clock.
I'm grateful.
Is the temperature bearable? It started quite warm, but the steps have been going on this morning to try and get the temperature down, which my own perception is are working.
Yes, I think it's working.
My Lord, I'm easy.
Good, thank you.